recommendations made by the council on its implementation. But now what kind of dispute resolution mechanism should be provided for? There is no guidelines given under the constitution at all. So it is left entirely for the council to evolve the way they like. Unfortunately for me, I would call it that they used an expression adjudicated dispute. If they would have said a resolution of dispute, I would have been more happy. Why? Because as Mr. Arun Goyal in the morning in Sanwa has explained to us the functioning of the GST Council, it appears that they are trying to evolve consensus on everything. So even if there be a dispute and a mechanism for its resolution being provided for, there should also be kind of a consensus mechanism, that you are able to evolve a consensus eventually. But the moment you say, they use the phraseology adjudicate the dispute, the problem starts. First of all, this adjudicating machinery will be created by the council. The council may be recognized under the constitution as a body. What power or authority that this council would have to delegate the judicial power of the state in a body to adjudicate upon? It's not parliament. Council is not a legislative body. It's not substituting the parliament of the state. I hope I made myself clear. It is only under the constitution that parliament enjoys the power to amend the constitution, which includes all the three kinds of powers: legislative, executive and judicial. Because constituent power is an assimilation of all. So while amending a constitution, parliament may create a body, authorize that body to have the power of adjudication. That means you transfer the power of adjudication, that is called the judicial power of the state, to a body. But a council which is subservient to a constitution, which is only a recommended body, how does this body create or transfer the power of the state? Judicial power of the state. This is judicial power. You have to transfer. That's why I find it very difficult to appreciate and to see what would be the eventual outcome of this. I don't know whether enough thought was given to this particular aspect or not. Maybe what you had intended, everybody had intended was that a mechanism for resolution of a dispute. That's perfectly all right. Not necessarily adjudication. Moment you say adjudication means there is a list. And if there is a list, you have to take evidence. And on taking evidence and entertain pleas of the parties and then come to a conclusion or a decision. That is an adjudicatory process, which is function of a court. And that power could be conferred by the parliament only. It cannot be through a delegate by a council. This is one major hassle or shortcoming that
is a serious inconvenience.
I find so, but subject to debate, I may be wrong. We may find a solution somewhere. Yes,
but if you look at the old draft, the draft is very clear, 279B.
That is by the constitution itself was doing.
Yeah.
That's a different thing.
No, but the intention of a list, probable list, was contemplated in 279B.
That's right. But as long as you have, that is a body which is constitution itself was creating, an adjudicatory body with the former Supreme Court or as previously the High Court and two other eminent persons, etc. You can create a tribunal of that kind and give the power of adjudication to that body. What we do for the National Tax Tribunal also is like that. You have one judicial member and other two non-judicial members. You can create such body. The only rider which the courts have said that once you are entitled to create authorities empowered to adjudicate upon disputes, this power is not taken away from Parliament. Because Parliament has that power while amending a constitution or by creating a judicial institution, it can confer that power. The only rider is that while making such a law or while conferring such a power on such bodies, Parliament cannot shut out the judicial review by the Supreme Court and the High Court. In fact, the earlier provision said that you can modify, you can exclude the jurisdiction of all courts other than the Supreme Court, but that's not enough. That's not enough because Chandra Kumar's case, as you know, Supreme Court has taken the view, and that includes both the 323A and B, both of them. So B is with regard to tax tribunal and A is for administrative tribunal. So both the articles have identical provision of exclusion of jurisdiction of the court. So the court has taken the view, you can create these bodies but don't have the power to exclude, because that this inherent power of judicial review of High Courts and the Supreme Court, it cannot be touched. Because then you are touching the core, the basic structure of the Constitution, which is unamended. So that cannot be done in any case. Not only that,
Is there an exclusion of the jurisdiction of High Court and Supreme Court?
yes, they are trying to exclude, no, and not now. The earlier proposal was, the present is none. It is not an adjudicated body even, properly speaking.
Then Article 131 may operate simultaneously.
Yeah, you are right. Article 131 only subjects itself. You just see the opening words of 131. It is subject to other provisions of the Constitution, right? Now, 269A or 279A does not provide for a mechanism to override Supreme Court jurisdiction, original jurisdiction under 131. If you had, then the question would have arisen as to whether 131 would at all operate or not. But since there is no mechanism by which the original jurisdiction of the Supreme Court is overridden or affected in the law, so that power would remain. To give an example, if you look at 262 of the Constitution, which expressly provides that the Parliament can by law provide for adjudication of interstate water disputes. And then sub-article 2 says expressly that in such a law, Parliament can exclude jurisdiction of all courts, including the Supreme Court. Now that is an original Constitution. No, Article 262 was enacted in was brought into force in 1950, along with other parts of the Constitution. And sub-article 2 empowered Parliament by a law, which is made under 262 itself, to exclude the jurisdiction of all courts, including the Supreme Court. And that was held to be valid. It has been gone into so many times, it has been held to be valid. Now, there is a law called Interstate Water Disputes Act, and that Act, Section 11 of that Act, excludes the jurisdiction of all courts, including that of the Supreme Court. But there is still an interesting arena which I must bring to your notice, because even where there is express exclusion by the Constitution itself and a law made by Parliament, the Supreme Court has taken the view that even in respect of interstate water dispute, the court's power under Article 136 is not taken away. Because 136 is not subject to the other articles, number one. That is one. Secondly, they say that on issues like jurisdiction of a tribunal, for example, even if it is an exclusive tribunal, they go interstate water dispute tribunal. But if the issue is regarding jurisdiction of that tribunal, then the decision of the tribunal on its jurisdiction can never be final. It is subject to a scrutiny of a judicial review ultimately. Therefore, on these twin principles, the jurisdiction of the Supreme Court under Article 136 is not excluded. There is another provision in the Constitution, Article 363, which seems to debar jurisdiction of the Supreme Court and all courts, which seeks to enforce, in a case which seeks to enforce a treaty or an agreement which is pre-constitutional. Now that provision has also been invoked on many a times, particularly in the Periyar dam dispute. This question was raised because the Tamil Nadu was seeking to enforce an agreement which is in 1928, etc. So it was pre-constitutional agreement that was to be enforced. So Kerala took the plea that this is the same pass, you have no jurisdiction to entertain such a plea altogether. The court, in fact, I had argued that point in Kaveri Water Dispute Tribunal before Periyar came. And Mr. Nariman raised the point and I countered him by saying that this doesn't apply, this applies to only political agreements and not agreements which pertains to the sharing of water system, which is not politics. At that time it may be, but it became part and parcel of the life of people. Because see, if you are used to a flow and utilizations over a period of time for say 100 years, the agreements are more than 100 years old, then they have become a part of everyday sort of life of people, and that cannot be subjected to a political will of someone. So that's not what is being intended. What was intended is that we had former ruler with whom we have entered into certain political agreements. Constitution, and before they merged, we gave them the right of privy purse and certain other privileges, recognition of rulership, etc. Those are agreements were not enforceable. That is why the bar of 363 applies, and that is why Article 131 also cannot bring in those issues. These are the only exceptions that have been made. So that's the position today so far as adjudicating machinery is concerned. We have yet to see how the council is going to, react to it and formulate the mechanism, what kind of mechanism it formulate, whether it will be really a dispute resolution. One thing that occurs to me is that although, as I said, adjudicate is a wrong expression used there, if they could have said a resolution for mechanism for resolution of any dispute, that would have been fine. Because very close example that I can think of is, like a mediation, for example, or a reference, short of an arbitration, because arbitration is a dispute resolution mechanism which is adjudicatory process. That's a quasi-judicial process, not arbitration. Conciliation, mediations, perfectly right. So something like that, if they are thinking in terms of, then they are out of the plan of judicial review, etc. Because then those parameters don't come at all in conciliation, etc. But if it is an adjudication, no conciliator has the right to adjudicate. That's a dangerous thing to do. So with that note, I think I will close. Anything else you want me to say? Because I don't want to go on repeating this.
Sir, I take the last point, that it is better to have used resolution.
And one more thing, I take your question, I forgot to say another thing more. Should we wait for 2 minutes?
Go ahead.
No, I was saying another thing, that why this revolutionary idea of GST, when it came about. The states were giving, but now where they are not giving. There is a background to that. The background is all started with Raja Challa's committee. He is the first one to say, look, we are going by a old traditional method of levying taxes on goods. This is not today. This is centuries old. Goods are always taxed. So they found out that, look, we have grown to a large extent, and if you look at our GDP, nearly 48% of the GDP was being, attributed to service. So an area on which nobody was taxing till then, neither Parliament nor the centre. Now 48% of the GDP is not a joke. It's almost half, and they have predicted this is only at the time being, and it's going to grow further. The service sector is emerging in a very, very big way. They were not looking at it at that time, particularly the IT sector. They are the ones who brought in this revolution in the concept of services. Otherwise, who bothered about paying some fees to an architect or engineer to a lawyer for that matter? Nobody bothered about all the services. But it is because, thanks to IT, because they made manifold, enhancement in their capital and in their earnings, which is beyond anybody's imagination. It was some 1,000 times of what could normally be a profit or a revenue of anyone in any business. I must say, to the credit of the former Prime Minister, the first Prime Minister of India, Pandit Nehru, when he introduced the first amendment to the which it was virtually the Constituent Assembly, because with their same, because still then the election had not taken place. Election was in 1952, so before that the amendment came, the first Constitution. And that amendment related to taxes related to property, right to property, etc. So in his speech, he said one very important thing, and this is what a visionary could only think about. He said, don't tribute on these rights of right to property. In future time, your properties will be something which you would never seen. He was meaning that intangible property. Who knew that IT would be a huge property? Has anybody envisaged that your IPR rights would fetch you billions of dollars will be their value? Who ever thought all this? But he did say, don't bother about this land, this piece of land. This is the fighting for land reforms. This is all in the context of land reforms. We have enacted a land reforms law. Patna High Court struck it down on some ground, not the whole of it. Only part of it. That was the misconception of all politicians at that time. They are fighting the courts on the wrong battle altogether. What the Patna High Court said was, that between the two landowners you cannot discriminate if they are positioned similarly. And they brought in Article 14 principle. So some provisions of the Act was struck down only on that limited ground, but it was projected by everybody. Look, we fought the independence only on the ground that we are going to improve the life of the peasants and the ordinary people, and you are judges sitting and striking down the reform laws. First thing that I did, the first amendment immediately came. That's how the whole background took place. Now, once this was discovered, that look, this is a huge field for resources for the government, that is that the service sector. And Government of India first tried, tested, because they have the residual power under the Constitution. So even without recourse to an amendment, which came much later, under the residual power, Parliament can enact any law, including a tax law. So 248, 88, 92, then ABC, etc. not necessary. The Parliament could enact any law, and they did. Any non-descript tax, but this was the descript tax. They were targeting a clear sector, that is the service sector. Then slowly and gradually, now look at this. Mr. Agrawal has also mentioned about the states were nowhere behind. They were trying to tax services from the 50s. Trying to tax, although they never had this power. The first attempt was by Garnet and Curley in Madras, so that you will know it. Madras government tried to tax the works contract as such. So that led to the court declaring that, look, you cannot do it because it's a composite contract, you cannot tax at all. Then the battle went, they never gave it up. The battle was so much that when the present President of India, when he was the Commerce Minister, he was persuaded by the state, please amend the Constitution to give us a right to tax at least this goods component in a service contract, not service contract as such. So they all agreed, and therefore the amendment came. The 629, you know all that history. So the states were always attempting. Not only that, there was another case where I appealed for some of these states. They were trying to tax the electromagnetic waves, sale of electromagnetic waves like your telephone, mobile phones. Most of the states were trying to do. I appealed for some of the states and try to argue that, look, this is also a commodity, like electricity. This is also good. This is a saleable product. But the court seemed to fail. That was one case which was fought at the level of the Supreme Court without an analysis on facts, because there was no assessment proceeding. All states and center, they all fought. I think BSNL took it up, the Supreme Court. They challenged the levies by the state right away without an adjudication. So nobody had investigated what is the nature of these goods, how does it operate, how does the mobile system operate. So in fact, I had to take a lot of trouble and read a lot of books to explain to the court what is this electromagnetic wave, how does it operate, how does the mobile phone operate, how does the electromagnetic wave transforms into a sound wave on either side. And then without a connectivity, electricity, you need a wire. This moves without the wire. How does it happen? Then the concept of boosters. Why do you need all that? So there are a lot of complications, but nobody knew about all that. So the court had a half-baked information, if I may say that. Sorry to say it, because there were no facts before them. I tried to persuade them, don't adjudicate these issues, remand it back to the concerned authority, let them go into this question, let somebody investigate the facts and then come take a decision on this article. But the court was persuaded by saying, look, this is basically a service. Primarily, predominantly a service. So you are tinkering into the state, central field, you have no such power. So that was decided from it. But the state was always trying to enlarge its, the field of legislation, trying to get more and more, because commodities are over. How many commodities you have? How many commodities are invented new? They are only different kinds of products. You have one air conditioner, one variety to another variety, some 20. After this air conditioner. Only in the service sector, which they will remain untouched by the state, they wanted to slowly creep in and gradually getting it. That is the primary reason when central government opened up the doors and said, all right, come on board. We can both exercise our legislative powers, enlarge our tax base. Don't go by the traditional taxing only the goods, go to the service sector, which has grown even more than 50%. Now you'll tell me what is the sector now? How much is the GDP now they are controlling?
No, it's more than 50%.
More than 50, that's what I'm saying. more than 50. So that's a huge, potential. Let's start it, together. And none of them had budgeted for it. Central government had never budgeted before the introduction. They started with 3 entities. You know what kind of service tax they have introduced? It came by a Finance Act, a chapter introduced. 3 items. This is how we started. Parliament never enacted a full-fledged law. Every Finance Act only added new services. It's a most confused state of law that they have worked for all these years.
No law at all.
That is absurd. I've said it 100 times, but it doesn't work at all. I don't know how it works for the administrators, those who have to administer the law, how does it work for them? If you don't have copies of Finance Act each year, you cannot administer that act at all. So from 94 onwards, how many acts you need
Even for
on your table? And then notifications. Acts are not enough. There's a notification. Absurd. See, there was a time when Central Excise Act was being operated only on exemption notifications. And at one point of time, the central government had to get rid of them because the number rose to 3,000 and odd. Only exemption notifications numbered more than, who can have a track of all that? So if you go to an assessing officer, he doesn't know how many exemptions have been issued, and every time, and in the middle of the year, it's not just financial year, at the time of finance bill that you do it. 10 times within the financial year you introduce new concept, new thing. Most indiscipline. Fiscal management in this country we have seen. So that would repeat some 3,000 and odd, notifications at one go. Anyway, that's how we started. So state found they were all the time wanting to get into that zone which they were not permitted under the constitution. They found it more profitable to go hand in hand with the central government. You get 50% of the share which you have never had anticipated. How does it matter? You lower your taxes on